Hello everyone, this is Anisha Sharma, intern at LEXIS and Company. I'm also a fourth year student at Modi University. In the current video, I'll be discussing the Industrial Dispute Act of 1947. Previously, I've made videos on topics related to environment, industrial and labor laws, and the company law. In the current video, I'll be discussing the Industrial Dispute Act of 1947. Also, a disclaimer for the video. This video does not solicitate or promote any kind of advertisement for the firm. It is only for educational purpose and in accordance with the rules as established by the Bar Council of India. Talking about the objective of the act. The object of the act is to ensure that a secure and industrial peace and harmony is provided, and a machinery is provided for the procedure for investigation and settlement of industrial dispute by negotiations. This act deals with the retrenchment process of the employees and procedure for layout, procedure and rules for strikes and lockdowns for the companies. The meaning of industrial dispute as defined under the Act. The meaning of industrial dispute is defined under Section 2A of the Act, where any employer discharges, retrench, or otherwise terminates the service of any individual workman. Any dispute or difference between a workman and his employee connected with or arising out of any discharge, dismissal, retrenchment, termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workman is party to the dispute. The significance of 1947's Industrial Dispute Act is that the act has adverse effect on industrial production, efficiency, cost, quality, and human satisfaction, discipline, technology, and the economic process, and finally on the welfare of the society. A discontent labor force or nursing its heart mute grievance, and it cannot be efficient, and therefore the productivity of the organization would be hampered by such a thing. So the Industrial Dispute Act, by settling the disputes, have worked as a positive motivation for the employees, which leads to the encouragement of employees, that there is a welfare legislation for their benefit, which will help them, and would there cannot be any retrenchment, dismissal, or discharge of employees without any reasonable cause by the employer. Talking about the scope of the Industrial Dispute Act of 1947. The Industrial Dispute Act of 1947 came in force on the first day of April in 1947. It aims to protect the workmen against the victimization by the employers, and to ensure social justice to both the employers and employees as well. The unique object of the act is to promote collective bargaining and to maintain a peaceful atmosphere in the industry by avoiding illegal strikes and lockouts. The Act also provides for regulation of layoff and retrenchment, and the object of the Act is to ensure industrial peace and harmony by providing a machinery and procedure for investigation and settlements of disputes by negotiation. The Act is quite lengthy, so in the current video we'll only be discussing the object, scope, and some important definitions of the Act, and we'll be continuing the video with the topic in the further videos. Talking about the important definitions of the Act, the major important definition under the Act is industry. So industry has attained a wide meaning than defined, and it does not only includes the domestic employment but covers from the barber shops to big steel companies that are established under the country. It covers all of them. Industry covers all of it. Also, the other important definitions are the definition of work committee, conciliation, the definition of conciliation as provided under the Act. What is industrial dispute? That is also provided under the Act. The word settlement is defined. Wages, then public utility service is defined under the Act. There are 7 points for the definition. Also, the dispute settlement authorities under the Act are given in the Act. They are defined under the Act. Thank you.